welcome to this webinar on the Appellate Body Crisis at the WTO. My name is Joost, and I'll just be giving the introduction. This event is organized by the Center for Trade and Economic Integration, but mainly and especially by the International Development Policy Journal. So do not think of this as your traditional trade lawyer event on the appellate body. What is behind this event is really a broader interest in emerging countries, especially smaller emerging countries, and how they are struggling, dealing with trade issues today. The event will be capped by a few comments from my colleague at the Graduate Institute, Wto Panizza, who is an economist, editor-in-chief of the journal. And it goes to show that the audience, our perspective here is much broader than your traditional WTO lawyer perspective. So my name is Joost Pauwelyn. I'm a professor at the Graduate Institute, teaching international law and also co-directing the CTEI. The context I've just given, we will be talking about the appellate body crisis and trying to focus on what it means for developing countries, emerging countries, in particular the smaller ones. Now you may think, why bother about this technical legal issue in times of coronavirus? I think we've seen how even in, or especially in times of crisis, keeping trade flows stable, providing security in the world of trade is important. And I think also, if not especially for smaller countries. So that will be our focus. Let me introduce our event a little further in terms of who will be speaking. Our moderator will be Fernando Pierola, from Peru originally. He's a senior lawyer with the Advisory Center on WTO law, the ACWL, which is, I'm sure, familiar to many of you. He's also an arbitrator, both on the free trade agreements and in investor-state arbitration. And Fernando, of course, has rich experience helping developing countries litigating WTO cases. So he'll be moderating. As panelists, we are very fortunate to have 3 speakers. Actually, we had 4 originally, and it's a real pity that Keke Mashigo of South Africa cannot be with us. Apparently, they have some issues using this particular Zoom system. But we'll be hearing from, first of all, Ambassador Santiago Wills, who's of course the ambassador of Colombia. Many of you will know him as the chair of the Fisheries Subsidies Negotiation Team, but Santiago also has a rich background in international trade law and how to deal with the crisis. Second up is Ambassador Manuel Tehankee of the Philippines. It's great to have you back at the Graduate Institute, former PhD student also here. Ambassador Tehankee has chaired the Trade and Environment Committee and now holds a very important job, the chair of the Budget, Finance and Administration Committee at the WTO, which may have some linkages also with what we'll talk about. Third speaker will be Katherine Connolly, who's originally from Australia, is a lawyer with Sidley, Austin, which of course is a famous law firm, but they also have a pro bono unit. And that's actually the reason why we wanted to hear from them as well, working with developing countries. Katherine will focus on that aspect, talking about it from the private law perspective. Katherine also used to work for the WTO Secretariat. We have about an hour and 30 minutes in total. And Fernando has promised that he will leave 30 minutes for Q&A. The way we will do this, if you have a question, please use the Q&A function on Zoom here. So on the bottom of your screen, you have Q&A. Write your question. I will keep an eye on them and then forward them to Fernando directly so he can read them out and deal with them. As I said, we are live. This is not pre-recorded. Hopefully it will all work out. There will be a recording available on links that we will provide to you after this event. Last thing, they've asked me to mention that there will be a post-event satisfaction survey. It would be wonderful if you can fill it out. It takes a minute or so, but it would be useful for us to know whether these kind of events work, how we can improve them, how we can make them even more interactive, things like this. With this, everyone welcome, and I now turn the floor to Fernando. Fernando, you have the floor. Thank you.
Thank you very much, Joost, and thank you for organizing this event. In principle, you have we have this. The idea was to have it in presence, but well, given the circumstances, well, this is going to be a very interesting experience. So, welcome everyone to this webinar on the crisis, the Appellate Body crisis at the WTO. My name is Fernando Pierola. I'm a lawyer at the Advisory Center on WTO law. I'm here in my personal capacity, though. I'm very glad to be with you, and I hope that all of you and your loved ones are in good health and remain safe. Now, before I give the floor to my colleagues, let me give a little bit of background of the current situation that we are facing. As we know, the WTO dispute settlement process contemplates a double-stage adjudication consisting of panel proceedings in which the facts are established and assessed in the light of the law, and appeals, which are limited to issues of law. Now, appeals are handled by the WTO Appellate Body. The Appellate Body is a permanent institution composed of 7 members who are chosen for a fixed period of time. And whenever the term of each of these members is coming to an end, the dispute settlement body starts a process for the replacement of that member. And in 2017, there were 2 appellate body members whose terms were finishing that year. The dispute settlement body was considering whether it was appropriate under the circumstances to have 2 separate selection processes or 1 single combined selection process for the choosing of the replacement of these 2 appellate body members. There were discussions for a few weeks, for a couple of months, until a major user of the system refused to join the idea of launching the selection process to continue with the appointment of the replacement for these 2 appellate body members. Some concerns were raised regarding the functioning of appeals by the appellate body in terms of procedure, the appellate body going beyond the 90-day period. In terms of substance, the question of whether the appellate body had gone beyond its competences in deciding some appeals. In any event, discussions have taken place for a long time. There is no solution found so far. There have not been new appointments for the replacement of appellate body members. In the meantime, the appellate body has been losing its members as their terms have been expiring in the meantime. And currently we have only 1 single appellate body member who is eligible to hear the appeals, but as we know, appeals can only be dealt with by a group of 3 in the form of a division. So panels at the first level continue doing their job. Panels continue issuing reports on a regular basis. If any party disagrees with the outcome, with the result of the panel, that party has the right to appeal. Appeals are received by the appellate body formally, but they cannot be processed anymore because there is no functional appellate body division that can hear the appeals. And this is the problem that we have now. If panel reports are appealed, given the current situation, the disputes remain unresolved. Now, the question that we're facing is, what is the impact of this on developing countries, and what are the manners in which developing countries could deal with this? And now, let me ask Santiago Wills, Ambassador of Colombia to the WTO, to tell us a little bit about the value of appellate body jurisprudence and the work of the appellate body generally for developing countries. Santiago, you've got the floor.
Thank you very much, Fernando. And first, I would like to thank the Graduate Institute and its Center for Trade and Economic Integration for kindly inviting me to be part of this distinguished panel. And Fernando, I'll just cut straight to the chase. I think there's many things that we can say on this topic, but I'll try to base my intervention here in maybe 3 points. And I would say that these are more of a 3 broad categories where I see value of AB reports, appellate body rulings for developing country members. A first broad category, I would say, and I think it's probably the most evident one, is the value of the report or the rulings from the appellate body in themselves when dealing with a particular international trade dispute. So of course, I'm going to go in depth in the 3 categories. I'm just going to name them first. The second category of value would be on the effects of a report from the appellate body in the design and implementation by members of their public policies. And I would say that on a third category, I would put the value of these reports of the appellate body when structuring members' negotiating positions on international trade agreements, either on a bilateral basis, plurilateral basis, or on a multilateral basis. So I'll try to deal with them in that order because I believe that's the way how the information leaks from one to the other one. So I'll start with the value of reports and rulings in themselves. So as you all know, part of the purpose of having a functioning dispute settlement mechanism, as is structured under the WTO rules, is to help members resolve their international trade disputes. The rules still envisage an appellate body as a second instance to review issues of law and legal interpretation that is developed by a panel in first instance, even though, despite the current impasse that Fernando was just mentioning. So as such, an appellate body report serves then to preserve the rights and obligations of WTO members under the WTO agreements and to clarify the existing provisions of those agreements. So, of course, I'm not going to go into the current debate of whether the appellate body rulings have exceeded their mandate or not. That would be a very interesting but a very long conversation in and of itself. So I'm not going to go that way. But when referring to this intrinsic value of appellate body reports and rulings for developing country members, I would just say that it is not necessary that such a member be involved in that particular dispute that is being resolved. So if it is, of course, it will have a direct effect because it will resolve the dispute of that developing member. But if it's not, an appellate body ruling or an appellate body report will in any case show such a member and the rest of the membership a more clear view and understanding of their own commitments, of their own rights and obligations under the agreement being reviewed. And I think this takes me to the second broad category of value of AB reports. And that's the value of reports and rulings as influencing the design and implementation of public policy, domestic public policy. So when the appellate body clarifies a particular provision or a WTO agreement, it usually presents its legal reasoning, interpretation, and rationale on what does that provision mean for members. Of course, under the dispute settlement rules, such analysis should be strictly done so on the facts before the appellate body and based on the specific dispute at hand. But of course, having a ruling that clarifies such provision is useful when planning ahead a country's public policy. As a matter of example, let's say the appellate body is set to review a panel report that deals with the subsidies and countervailing duties agreement in the WTO. In such a dispute, let's say the AB establishes an interpretation of what means that a subsidy is granted, let's say contingent upon export performance. And in other words, if such a subsidy is to be considered as prohibited. So on the one hand, and dealing with my first category, that interpretation and ruling will result in a determination of whether the respondent, say it's a developing country or not, is compliant or not with its obligations under the WTO. On the other hand, and on this second category of value that I'm mentioning, other members of the WTO will see this interpretation and will have a better understanding of what they can or cannot do. So this helps shape public policy that should, in any case, be compliant with the WTO agreement. So before such a report existed, let's say, a particular member could interpret by their own that the provision would mean something that by default will allow them to do, let's say, take measures on a specific subsidy program. But once you have an appellate body report with an interpretation of how that specific provision has to be read and how that obligation is meant in that specific WTO agreement, then maybe that member will have additional legal elements to see whether, in effect, the policy that they're trying to implement or design in their domestic jurisdiction will be or will not be compliant with its international obligations, and in this case with WTO commitments. I guess that this category of value, we can summarize it in a few words, and that is that appellate body reports give further elements of analysis to trade policy makers in order to design and implement policies that are compliant with its international obligations. And I'll just jump into the third category of value that I mentioned at the beginning. And that is the one that is based on the effects of countries' positions on different trade negotiations. So how appellate body rulings influence countries' positions in negotiations. So as for the second category mentioned, the legal interpretations brought by the appellate body clarify provisions that are most of the times reflected and sometimes even copied and pasted into free trade agreements. I guess we've all seen free trade agreements with a copy paste from different provisions of the WTO or explicit reference to agreements of the WTO. And I would just say that not only free trade agreements, but also different types of agreements. I've seen provisions from the WTO almost copied pasted into into bilateral investment treaties and other sort of treaties. So having better clarity of the provisions in the WTO that serve as basis for bilateral negotiations or multilateral negotiations give elements, legal elements to the parties and legal value to the positions of those parties. So for instance, when negotiating a bilateral free trade agreement, a party to that agreement may explicitly exclude or intend to exclude matters from a provision negotiated in that agreement that would otherwise be understood to be included as per an interpretation of the appellate body in the WTO framework. So if in a bilateral negotiation, we're taking as a basis a provision of the WTO, then let's say as a matter of logic, we're taking as well the rulings and interpretation of those provisions. So once we have that or a clearer view of what that means in the WTO, we can see what we can do with that same reasoning in an FTA, in a bilateral agreement, plurilateral or multilateral. And I must say that I have seen it recently in a multilateral basis in the negotiations on fisheries subsidies. I'm not going to go very deep in this, but as you may know, we now have 25 years of appellate body activity in the WTO. And in the negotiations on the fisheries subsidies instrument that we're trying to negotiate in the WTO, we're starting to see, and from many years ago as well, members using appellate body reports as a basis for their positions. So for instance, you can see that there are proposals, there are discussions on how we should understand contingency of a subsidy on a specific deal with the fishing activities. And those contingency or the interpretation of contingency is based in part upon what the appellate body has said in previous cases. So it's interesting to see how the appellate body rulings in general have a direct effect on those members dealing with a particular dispute, trade dispute, but then it leaks into the design and implementation of public policy and even into members or countries' positions in bilateral agreements, plurilateral agreements, and even in this case, the multilateral agreements we're negotiating in the WTO. I see that I don't have much time left, so I'll just leave it there and maybe leave some space for questions afterwards. Thank you, Fernando.
Thank you very much, Santiago. This is very interesting. The impact on domestic policy making, the impact in terms of trade negotiations of the rulings of the AB. Now let me give the floor to Manuel Tehankee, Ambassador of the Philippines, who is going to refer to this issue more specifically. And for all the audience, I would like to remind you that please, if you have any questions, use your Q&A function at the bottom of the screen. Manuel, the floor is yours now.
Yeah, can you hear me now? Good. Thank you, Fernando, and thank you to the Graduate Institute, my home academia in Geneva, and of course the CTEI Professor Pauwelyn, and the organizers of this webinar. I'm really pleased to be here with Santiago and Katherine and Fernando, and I have the task of discussing a developing country perspective, experience with the AB process, and also touch upon the current crisis. As background, as pointed out by Santiago, we indeed, the Philippines, as a developing country, sees the three benefits mentioned by Santiago over the last 25 years. which is a transition from a rules-based system, because Philippines is indeed a light user with 5 cases as complainant, 6 cases as respondent. And we have also participated in 18 cases as third parties. So on the transition, so our experience has been quite positive. As a transition from the GATT era, wherein power politics ruled, it's kind of very reassuring at the beginning of the WTO that we would transition to binding rules-based settlement, dispute settlement. So in our cases, as a light user, we have experienced a resolution to those cases. Second is on the domestic reform impetus. Santiago said, the Philippines has used a lot of its WTO experience in reforming our local legislation, passing new legislation, as well as in our negotiations within ASEAN and our FTAs. Indeed, it has been instructive. So there is a benefit for the Philippines to participate in this multilateral dispute settlement system. However, on the third remedy, the third issue for developing countries is the remedies. So indeed, we do have the benefit of a rules-based system. We do have the benefit of domestic policy reform and the instructive benefit of negotiating our own FTAs. But the third benefit that developing countries were looking at for the dispute settlement system of the WTO was a viable remedy for complaints of our constituents or exporters. So it is, in seeing the benefits, I think we can identify one of the problems developing countries has faced with in the current AB crisis, and one of its complaints, I guess, on the general need for reform of the WTO dispute settlement system. And this goes to the third element of a remedy for domestic constituents to seek, I suppose, trade justice or trade reform for their exports. In this third element, I suppose the problem we see is the time lost. And then the second element is the binding nature of rulings of the AB. And of course, the current crisis of the AB. What will developing countries be able to do? From the Philippine perspective, for example, a lot in one of our cases, for example, in the, I suppose the Thai cigarette case is one, which is affected. And here, I think the discussions on WTO reform relate to the fact that the time periods originally envisioned in the WTO dispute settlement system have not been exactly strictly followed. So in certain instances, there is long delays in resolution of the dispute. The second is, from a general perspective, developing countries have also noted that there is still a great influence by the power, the trading power of the participants to the dispute settlement system. The binding nature of a particular ruling is sometimes dependent on the strength or ability of a winning party to enforce the ruling of the, I suppose, the panel or the AB. And of course, now that we have a paralysis of the AB, that would be the third element, wherein developing countries, I suppose, are more disadvantaged than larger developed nations in enforcing or ensuring their trade interests are protected. So those would be the three general deficits that developing countries are looking at in terms of the current crisis or the need for WTO reform. Thank you.
Thank you. Thank you very much, Manuel. We'll get back to the question of experience a little bit later, and the question of remedy certainly is something of concern to all the members, which may go beyond the question of the specific appellate body crisis. But now moving a little bit forward in terms of what is happening next, how can we react to this? If we look at the system as it stands now, it seems that currently most of the dispute settlement work, except for those cases for which appeals were filed before December, are mostly relying on the work of panels. It is a system where panels are doing most of the adjudication work. I think there may be a question as to whether this is certainly sustainable in the long term. Joost was referring to a very important notion in our trade community, which is the question of security. And security is an important value, more so in times of crisis, as the current situation that we're living in. Now, in the light of the fact that the current system is mostly reliant on the work of panels, what is the manner in which, given the fact that this could be problematic, given the fact that countries have the right to appeal, but there is no functional appellate body to address these appeals, what is the manner in which developing countries are thinking of dealing with this situation? I know that there is at least, I know at least of one case, one instance in which some developing countries consider that perhaps waiving their right to appeal for a specific dispute in a specific instance was one way of dealing with this situation. I know that there are some other situations where countries are thinking of substitutes for the appeal process. And this takes me to the presentation now of our next panel fellow, Katherine, who is going to talk about the multi-party interim arrangement. Katherine, you've got the floor.
Hi, thanks, Fernando, and thanks as well from me to the organizers for the opportunity to speak on the panel. So I would like to touch a bit today on the practical response of the membership to the AB crisis, including, of course, the Mpia, which I will explain and get to, and relevant takeaways from this response for developing country users of the DS system. But I think just stepping back a little bit on this topic, I think if there's one thing that's clear, it's that the WTO dispute settlement system that emerges from the crisis will run differently in some ways. So whatever the long-term solution that the membership agrees on, there will likely be some changes, including procedural changes as well, to the day-to-day running of disputes. So I think in responding to this situation, the membership has an opportunity to think more broadly about what they want dispute settlement to look like in the future. And it's really important that that process includes the perspective of developing country users of the system. So of course, those who follow this area closely know that there have been lengthy discussions for years with plenty of technical proposals floating around on how to improve access and effectiveness of the system for developing country members, and particularly for small members. But I think what we've seen is that when things run smoothly, and that really means when the system functions well for the big players, not a lot tends to get done because the impetus and pressure to change things isn't there. So really a silver lining of a crisis situation is that it provides that impetus and pressure. So to take just one example where I think some progress arguably has already been made as a result, really a direct result of the membership's response to the crisis, is in implementing procedural reforms to improve the efficiency of disputes. So a major criticism of the DS system from a developing country perspective is that disputes, particularly in recent years, have become so large and so complex as to present real accessibility issues. And I can say from a practitioner's perspective, it's true that the human resources and expertise that's required to litigate a dispute these days, that's challenging even for large developed countries. So it's very understandable that it can be just prohibitively difficult for developing countries to participate. Now, this is an area where, of course, there's been a lot of talk about introducing procedural reforms, but it's only now arising out of the crisis that we're really seeing practical steps being taken. So that brings us to the Mpia. As many members in the audience will know, a group of WTO members, including a number of developing members, have just announced an alternative appeal mechanism, which basically will function as a parallel option for members to use WTO arbitration under Article 25 of the DSU to litigate their appeals for as long as the appellate body remains non-functional. Now, a number of proposed reforms on efficiency of the system have found their way into the MPIA. So that includes basic ideas like giving arbitrators the option to impose page limits, limits on the number and length of hearings, but also some more far-reaching substantive measures, including a kind of summary judgment process where parties can be advised by the arbitrators to drop claims early in the process, with the potential of quite significantly reducing the size of the dispute. So that's what's happening in the MPIA. And I'll just, as a quick aside, I've noticed that we've had some questions come in about participation of small members in the MPIA. It's true, there are some developing country members that have participated in the group of 16. It's true that not a lot of those are small members. And I think that that's understandable because the impetus and the pressure to be on the vanguard of this issue is really on those members who most frequently use the system. So I think what we'll see is that smaller countries may hold off, see how the system functions, see if it works well before deciding whether to sign up. And that option remains available to them. A member doesn't have to be in that group of 16 in order to join. But so taking even this smaller group, this group of 16, what we're seeing is that directly because of the crisis, the trade community will now get to see how and whether these ideas on things like procedural efficiency actually work in practice. And it could well be that those types of reforms are carried over into whatever the long-term solution is. Now, I think that measures like this to streamline disputes and make the process lighter and more efficient are beneficial for everyone, for all users, but they do have particular utility in improving access to those members with capacity issues. So of course, this is only one example, and I appreciate that when it comes to reform of the dispute settlement system from a developing country perspective, there's a deep set of issues to be discussed. Some of them have been touched on already. It would probably be a panel in and of itself. But I do think what we're seeing coming out of things like the MPIA is two things as a result of this crisis. The first is that existing reform ideas are moving from being purely theoretical and academic, which they've been for years, to actually being implemented in practice. And second, we're seeing an appetite and a willingness for innovation in dispute settlement procedures that perhaps previously hasn't been there. So I think if we perhaps can look at this situation as a rare opportunity for reform, if we think about it that way, then what's really crucial is that there is developing country participation, including small developing countries, at this stage right now, in the process of the membership, thinking through what dispute settlement should look like in the future. We've already seen a little bit of that in the MPIA, but I think it's important to maintain that as a priority. Thanks.
Thank you very much, Katherine. Before we move on to the second round of comments, I guess Ambassador Wills from Colombia may want to give some comments from his involvement in the MPIA negotiations and the perspective of a country like Colombia. Ambassador, you've got the floor.
Thank you, Fernando. And I would like to take long here, just maybe to add something from what I heard from Katherine and from Ambassador Tehankee as well on this topic. And I mean, I just want to share something that we lived through this at the beginning of this year when we were negotiating the MPIA with the rest of the member participants in this initiative. That was very, very widely led by the European Union with a lot of effort. And that's that small delegations here in Geneva with support from capitals, we had to engage a lot in these negotiations. And it took a lot of time and it took a lot of effort from those delegations. So I mean, it's easy to see that small delegations, small developing countries that maybe don't have enough people here in Geneva, enough human resources, would have a harder time to get involved in this type of immediate initiative that took basically from, I would say, December to last month. So that's about 4 months to negotiate an alternative to the appellate body while it's resolved that impasse. So maybe that's also an explanation of why it's just some small developing country members. But if you take the European Union as one, I would say that almost half of the participants in the MPIA are developing country members. And I do think that there's a case to it, and that's that keeping a second instance and appellate review in the WTO dispute settlement mechanism helps maintain a certain level of accountability on panels. So when you're an adjudicator and have a group of people that will review your analysis and interpretation in a particular case, I'm pretty sure that as an adjudicator, you will take better care of what you write and what you say in a particular case. Maybe more rigor is required. So I do think that having that extra pressure from another group of people that will review on an appeal, that the analysis of panels will keep certain level of accountability to those panels. So I do think that part of the considerations that we as a delegation had here to engage in these negotiations, and many other members as well, was to keep the panels as well with a certain rigor and a deep level of accountability, as we've been used to for the past 25 years. Thank you, Fernando.
Thank you, Santiago. It appears that Manuel, Ambassador Tehankee, may want to comment something a little bit on this.
Yes, thank you, Fernando, and thank you to Katherine for those remarks. As we segue, before we segue to the second round, of course, I think just to answer the questions on the MPIA, as well as what Santiago has said. For developing countries, then, we are looking and observing what will develop with the MPIA. So many developing countries, including us, are looking at it seriously. But definitely there are two outcomes from the AB crisis. That's why one perspective of looking at the MPIA is it's the positive aspect of its keeping to the legal system. Remember that in the GATT, there was a lot of power politics determining the result. And so with the WTO, the benefit is having a legal system moving forward. And I think the MPIA continues with this so-called legalist approach of settlement of trade disputes. But with the crisis, we are also being thrown back. As mentioned, we have gunboat diplomacy as the theme for the transition from the GATT, transition away from gunboat diplomacy to the new system. But as we throw back to the GATT, with the AB paralysis, I think we are saying that we're going back to GATT. But we're forgetting that the GATT also had some very good silver linings and benefits, which was the not pure legalist approach, which would allow for compromise, allow for certain solutions, creative solutions among parties to solve trade disputes. So I think as we comment on the MPIA, we are observing whether the MPIA leads purely to a legalistic resolution, or does it also address some of the reform issues which the original vision of the GATT and the WTO combined was a semi-legal, very constructive trade arbitration mechanism. So I think that's an important issue as we always go back to the GATT. We have to think of the pre-WTO quasi-legal approaches. Thank you.
Thank you very much, Ambassador Tehankee. With this, we finish the first round of comments. Now I'll give the floor again to our colleagues. Perhaps we follow the same order. If you have anything that you may want to add on this matter before we move on to the Q&A section, I'll give the floor first to Santiago.
Thank you, Fernando. Well, at this point, I think that on what we thought about the MPIA, what was said by Ambassador Tehankee and by Katherine as well, I wouldn't say that I have much to add. So maybe I'll leave it there and just give some more time for the other panelists to hear their views as well. Thank you, Fernando.
Thank you, Santiago. Manuel, your turn.
Well, there is a question. I don't know if we should already respond to the questions, Fernando, or do we, because we do have quite a few questions to Santiago as well on the FTA obligations and others. I don't know if Joost wants to come in and say something or guide us on this.
Let me ask Katherine if she's got something to add here. If not, we just move on to the Q&A section. Katherine?
I'm happy to move on to Q&A. I will say that I think one of the benefits of the MPIA, there's a few things. I think that we're increasingly going to have a situation where the DSB is going to be put in a difficult position because members are going to be reluctant to have a situation where, let's say you have a panel report in your favor and members can't get that panel report adopted. That's going to create some uncomfortable and often quite political situations for the DSB. And I think what the MPIA offers is basically a way out of that situation whereby you maintain all the flexibility that you have under the DSU. You have the choice of whether or not to opt for an appeal. You don't have to commit in advance to not opting for an appeal. And so I think that that will likely remain an attractive option for members in the future. But I'm happy to go to questions. I think that the time would suggest that we should.
Thank you very much, Katherine. So maybe we are moving to the question section. Let me just check here.
Fernando, if I may, there's quite a number of questions, and I don't know whether I click on answer live. Can everyone now see the question?
Yes, we see the questions. We see the questions, so you can choose which question you wish, Joost. Yeah.
So Fernando, perhaps you can, because there's 24 questions listed now. I don't know, I can also try and summarize some of them and turn the moderating to you. I've seen a lot of questions on the MPIA, and as I told you, there's a lot of people who are not legal experts. So perhaps a few more words on, is this linked to the DSU? How old is the MPIA? And then lots of questions on what does it mean for developing countries? This MPIA, why is it that, say, African countries are not joining? Where is South Korea, India, Iceland was mentioned? Would Philippines, ASEAN countries join? And a lot of questions also on, if I'm a developing country, should I join this? What is in it for developing countries? Is this going to be permanent, or is it just something interim? So more generally, what should developing countries do and what can we expect? So I don't know whether Santiago, Manuel have ideas on why is the list indeed relatively small at the moment? I'm sorry, I'm summarizing like 10 questions.
So I suppose to break the ice, but I want Katherine to answer this directly, and Santiago. So I'm just going to introduce and say, well, developing countries, of course, were not in, because as pointed out, there was a lot of negotiations in the WTO on a possible Article 25 option. But many developing countries, perhaps led by Mexico, and this I'm just speaking not really as a national position, but really just as an observer of the WTO process. I've observed that many developing countries have participated with the leadership of Mexico in really urging solution to the AB selection of AB members set stalemate. And so a lot of developing countries were really had that hope and wish that eventually the stalemate would be solved and things would be better. So I do have to acknowledge that over the last year and a half, many developing countries have put their voice forward, participated, urging a solution, participated as well in the so-called Walker process, which was a long process of trying to craft solutions and different WTO reform issues. So we have to acknowledge that developing countries were really focused on this. And the second hesitancy is also that there was a general fear that this means you're really finished with the AB. So of course the MPIA says it's interim, but there is a lot of concern. I'm just gathering from others that there is a concern that this may lead to a real different system, and meaning the end of the AB. And the third, of course, I've mentioned already in my earlier intervention, there are those in the moderate camp are looking for actual WTO reform and quasi-legal solutions, because that has been one criticism, that the purely legal approach is not necessarily the original intent of the GATT WTO system. Thank you.
Santiago, would you like to add something on this, or
Yes,
I
yes, I
noticed
can
that
say something very brief. Thank you, Fernando. And just to add on what Ambassador Tehankee was saying, I do think there's a practical reason or a pragmatic reason on why at this point we don't have a lot of small developing countries participating in the MPIA, and I mentioned this briefly before, and that is because once the negotiations actually started, it's been only about 4 to 5 months since we have already concluded, let's say, that stage of negotiations and moving into notifying this mechanism to the dispute settlement body. And that has taken a lot of time from delegations participating and going back to capitals, asking for instructions on what to do, what to not do, etc. So I do think that let's say the short period of time that we've been actually negotiating on it has taken a toll on how many members and how many developing members could go from the beginning, from the start, to these type of negotiations. I do have to say, however, that and I agree with what Ambassador Tehankee was just saying, many developing countries members in the WTO have presented their support to the appellate body and how we should resolve the appellate body impasse at this time. And I must say that that's the same for the members that are participants of the MPIA at this time. So we have all established and we have all stated very clearly in our negotiations, but also in the texts that we're putting forward, that this is an interim arrangement and that our priority will still be fixing the appellate body impasse, whether that means a reform, whether that means convincing X or Y members in doing something, but our plan A is still working towards the fixing of the multilateral appellate body impasse. This is an interim arrangement that will help a second instance of appellate review survive and let us keep going in our let's say dispute settlement mechanism with a two-tiered approach with all the let's say positive consequences that would have. So I will just leave it like that. Thanks, Fernando. Thank you
very much, Santiago. There is here a question for Katherine. I can read it out. You refer to the MPIA arbitrator's ability to suggest Article 11 claims as a sort of summary judgment. To what extent does the use of the mechanism imply arbitrator's view about the substantive merits of a claim, as could be the case in a summary judgment context? Could a more meaningful type of summary judgment on the merits be envisioned, whether at appellate or panel level?
Thanks. That's a great question. I think I might back up a little bit by just giving a very brief kind of technical description of how the MPIA works, because I'm aware that not everybody's necessarily familiar with it. So the MPIA it's in 3 parts. The first part is effectively a political communication. It's not a treaty. It's not binding. It's a political commitment by the participating members to use the MPIA appeal arbitration mechanism. The way that that's made legally operational in a particular dispute is by notifying a template Article 25 agreement, which appears in Annex 1 of the MPIA. So if you Google the MPIA, you'll find a document that has Annex 1, and that is a template kind of draft agreement that the parties would notify. And it's in that Annex 1 that there is discussion about some of the procedural mechanisms that we've been talking about, such as this summary judgment process. Now, going directly to the question, what would this suggest about the arbitrator's view of the claim? Well, so the MPIA is very clear that this would not be a kind of binding recommendation by definition, that it would be up to the parties ultimately to decide if they wanted to withdraw the claim or not. If the party was extremely confident in its claim, perhaps had its own reasons for pursuing that particular claim, they can do so, and the recommendation and the refusal of the recommendation is not without prejudice to the party's claim. The MPIA explicitly states that. That said, from my perspective, if I was in a team that was litigating a case and we had communication from the arbitrator early on in the proceeding saying, listen, I don't think that the big bunch of Article 11 claims that you've brought has much shot of success, and we would suggest that you drop those. I think that, you know, you would get the message about what that would mean. So I think this is a kind of a good example of a sort of a quote unquote soft measure by which we can start to kind of streamline and reduce the sizes of disputes. It doesn't affect parties' rights under the DSU because it's not binding. Parties can still bring the claims that they want to bring, but it's a good communication strategy to the parties, between the parties and the arbitrators, about the kinds of claims that are going to succeed.
Thank you very much, Katherine. I've got here a question for Santiago concerning the fact that some FTAs incorporate WTO obligations. There is a question on whether we should expect an increased resort to those FTA provisions and FTA dispute settlement, particularly in the light of the current crisis.
So let me see if I understood the question. Is it that given that some FTAs incorporate WTO provisions, whether we would see say disputes going into the FTA mechanisms? Is that the question?
Correct. In the light of the current situation where the dispute settlement process here, the WTO is having some crisis.
Okay. Well, I mean, I think when as a government, when as policymakers in general, when you take a decision to take a dispute either to the WTO or to a regional trade agreement dispute settlement mechanism for anything, I think you make a certain analysis of various elements. And I think there's an element that is very important to choose of why you would choose to go to the WTO instead of going to an FTA. And that's the exposure that dispute will have in, let's say, around the world in general, in the global trading system. Sometimes when you're trying to fight something, a measure from another member that is affecting your exporters, for instance, it's a measure that also affects other members of the WTO. And for developing countries, it's of great use to be able to use support from other countries in those disputes, to find more leverage in trying to get that dispute to be taken seriously, even to distribute costs of those disputes. So I wouldn't be sure that just for say, based on having WTO provisions, let's say copy pasted almost to free trade agreements, I don't think that necessarily that would mean that those disputes that would be taken to the WTO would be taken to a bilateral or regional trade agreement. I'm not sure. I think there's various different elements that would still incline developing members to take that to the WTO. So I wouldn't say that's something that we'll necessarily see happening. But of course, you can never say never.
Thank you, Santiago. There are some questions here relating to the COVID pandemic. And the questions go to the fact that currently we have seen that various WTO members in response to the crisis have taken different type of measures that have an effect on trade, export restraints, IP-related measures on the use of drugs, potentially the use of compulsory licensing. Do you see that perhaps, you know, given the problematic we're facing now, there is a call for international cooperation? You know, the IMF statements, the WTO, the G20 have put forward the idea of global talks as the first option. But if this doesn't work out well, then people may turn around and look at the dispute settlement process. How do you see that, you know, the dispute settlement process would react to this type of situation where there is an avalanche of measures relating to COVID? And this question is for comments or inputs by everyone. Manuel, you may want to.
Katherine, do you want to answer that, or?
I think that's one for the ambassadors. I mean, I would just say, I think it's really difficult to predict. I think if there's one thing that we know about this crisis, this situation, is that it's totally unprecedented. And I for one wouldn't be able to say that, you know, countries will react in XYZ way and the dispute settlement system will deal with it in XYZ way. You know, let's try and have a dispute settlement body meeting.
There's also a question, I think, for Katherine on the summary judgment mechanism from Jesse. That it says, could a more meaningful type of summary judgment mechanism on the merits be envisioned, whether at appellate or panel level? So suggest Article 11 claims as a sort of summary judgment. I think, Katherine, you can mix that in also with my comment on a few questions on the legalization and judicialization trend, which has been one of the criticisms of the dispute settlement process. And I think Christopher and Yannick have raised that question on whether this trend to judicialization impacts sovereignty or supranational comment. So I think summary judgment is somehow related. It's also the question on the purely legal approach comment I made. So there's also a question on that. So basically, the question is, there are mechanisms for a purely legal dispute, but in other trade disputes or commercial disputes, there's really a need for rapid or faster, more efficient types of dispute settlement, which resolves the dispute and move forward. So I think in the future, there will not only be one type of mechanism, not only one type of, not one size fits all. So I think that's something for reflection. And this summary judgment approach of the MIA is actually a sub-branch of this attempt to have faster or more efficient dispute resolution. So I hope I've answered some of the concerns, which moves back to WTO reform. And it also answers, I suppose, part of the question, what happens when the crisis is solved? What happens to the Mpia jurisprudence? So, of course, there's no precedent in WTO law, but I think there's always persuasive effect. So I pass that on to Katherine and Santiago.
Fernando, if I may, I'm trying to put together a couple of questions, and one that stood out to me is, and that's directed to Santiago, I assume. Just taking a step back again to the big picture. Santiago, you are in charge of the fisheries negotiations. There's a question there about if there's no functioning dispute settlement, what impact does that have on negotiations? What's the relation there? Was a question from Gary. So if Santiago could take that one, and then I think Fernando could perhaps have a go at that one as well. There's a number of questions that are asking, okay, given the WTO crisis, what lessons should other organizations take from it? So in the world of investor-state arbitration, they're looking at the WTO as an example to copy in terms of an appellate review. What should we think of this now? There's a question on the African Continental Free Trade Agreement, where they also set up a dispute settlement mechanism. What lessons can we learn from the WTO crisis, the failure that we're going through now, for these other mechanisms, things they should copy, not copy? So perhaps Santiago can go first on the fisheries negotiation, and then I'd be curious to hear from Fernando on the lessons for ICSID and from anyone on the lessons for the African Continental Free Trade Agreement, ASEAN or USMCA, the lessons, what could we do to avoid that a similar crisis arises in other settings?
Great, thank you, Joost. And Gary, thank you for that question. I would first start saying that if members keep working on a good faith basis, we still have a functioning and a binding dispute settlement. And what do I mean by that? We still have a panel process. Of course, the right to appeal is still there in the text, and that's the danger. So if we don't work on the basis of good faith, then we risk the possibility of not having a binding dispute settlement mechanism if a panel report is appealed into the void, as was mentioned before by both Katherine and Manuel as well. So, but if we do work on the basis of good faith, then we still have functioning dispute settlement body, dispute settlement mechanism, and binding to members. I would then say that thinking about dispute settlement during negotiations is of course very important. And as I mentioned, I've seen members basing their positions, basing their proposals on past reports of the appellate body and panels in how to structure the new provisions that we are trying to negotiate. However, I do think that thinking on dispute settlement while negotiating and how to take one member or the other into dispute settlement, or how to defend my position not being challenged in dispute settlement while negotiating, I think we're missing, or we're going ahead and skipping one huge step that is key, I think, and it's embedded on the values of the World Trade Organization, and that is the good faith implementation of our obligations in the WTO. So if we manage to have a legal instrument, let's say on fisheries, that says we cannot do this, well, the first step for us as members is to acknowledge that and to comply and implement our measures implement those obligations in good faith. And then, if after we do this in good faith, by a mistaken interpretation, by different types of reasons, we go into dispute settlement, then it's something that will be, let's say, actively a consequence of what we negotiate in the agreement. But I do think that for negotiations, we need to keep thinking that as part of our values of members in the WTO, we should implement those obligations in good faith. And if we keep the basis of good faith, then we still have functioning and binding dispute settlement mechanism. It's just when we are not acting in good faith, when we can throw these appeals into the void and block a dispute settlement process.
Thank you very much, Santiago.
Yes.
Sorry, Joost, would you like to say something?
No, it'd be interesting to hear also from you, Fernando. I know you try to hide behind your moderator role, but you have a lot of experience as well.
Well, see, the question of having some sort of appellate body or something similar to the Wto Appellate Body in the investor state scenario is something that has been discussed extensively. As a matter of fact, there are specific proposals in that respect. I guess it's still, a question under debate, because there are certain features that are different from the system we have in the WTO area. One of the main roles of the appellate body of the WTO is precisely to provide certain type of coherence or uniform interpretation in terms of the several provisions of the WTO agreement that would apply generally to all WTO members. Now, in the investor state dispute, we don't have the same uniform multilateral framework in terms of substance that would apply the same way to everyone. We're talking about bilateral investment treaties or some regional agreements or some sectorial agreements that may be subject to specific interpretation. So the need for that type of a specific coherence perhaps is not really at the same magnitude as the one we have at the WTO. And certainly also there is a question on the type of remedies that are sought. Usually in WTO dispute resolution, we're looking for some type of ruling from a panel or the appellate body that may have an influence on a specific policy of a country. So in a certain way, the goal of the system is a little bit ambitious. You are seeking a change in policy for a particular country. In investor state, we're not necessarily, or let's say claimants are not necessarily pursuing the same goal. There is the goal, the main objective of a proceeding is to find a remedy, a specific remedy which could be quantifiable and which could be translated into specific monetary terms. There is no this policy change, let's say, driver behind the bringing of a case. I'm talking, of course, in the ordinary, with respect to the ordinary cases. So perhaps, the need for the same type of appellate review scheme is not the same. though certainly I must recognize that there are some efforts to go in that direction. What are the lessons that can be taken from the WTO Appellate Body system? I believe, this could lead us perhaps to some of the concerns that have been, let's say, behind the criticism of the functioning of the appellate body. I guess, if any type of appellate body court or appellate court were to be considered investor state scheme, I would think that certainly there would be some safeguards to avoid any type of criticism about judicial activism, for example. The role of states is not really that, let's say, that lively as the one we have in the WTO forum. In the investor state area, it's mostly the participation of states and particular investors. So I don't know to what extent in that respect there would be some room for certain type of political maneuver to, let's say, lead an appellate court on investment to a situation that like the one we're facing here. This is what I can say for now.
Okay, if I may throw in another bucket of questions. A lot of questions relate to actually what Santiago started off with, the idea of predictability, how appellate body case law can play a role, especially for developing countries. A lot of questions on what will be the role of this appellate body precedent for the Mpia system. And in turn, people asking, well, if the Mpia will come out with rulings, what will the precedential value of those rulings be for any appellate body that may be restored sometime down the road? So a question of also, how, will this Mpia not lead to fragmentation? Panels, perhaps an appellate body in the past, Mpia now, will it lead to fragmentation? Or other people are indicating it may be a flexible mechanism that leads to innovation. So what do people think about precedent and the challenge of fragmentation innovation here? And perhaps we can start with Santiago and then Katherine, because it is, many of these questions are relatively legal technical. Thank you.
Well, I'll probably start by saying that even with no Mpia, there's a general understanding that there's no precedent in the WTO. So even AB reports do not constitute precedent for further dispute settlement, say further disputes in the WTO. So having said that, let's say on the basis of that, I would say that having the Mpia mechanism, being able to resolve on an appellate review those other issues that maybe have had certain interpretations already by the appellate body, given that there's no precedent, there shouldn't be any fragmentation at all, given that there's no precedent on a legal standpoint. But what I do think, and something that we do need to acknowledge, is that, as Fernando was just saying, part of the role of the appellate body, and in general the dispute settlement mechanism, is to provide members on say predictability and security on a predictability of the multilateral trading system. So having, let's say, a panel of arbitrators in the Mpia interpreting an agreement on a contradictory basis of what we already had, let's say, 15 years ago from the appellate body, well, we might be facing that type of fragmentation that you're mentioning, Joost. And again, I wouldn't say it would be a legal fragmentation if on the basis that we don't have precedent at this point. But I do believe that we need to find out the best views, the best ways to avoid that in any case, and to see when, if eventually we have a functioning AB again, what would happen with those reports presented by the arbitrators under Mpia vis-a-vis the rest of disputes on a multilateral basis. I think it's not just at this point what will happen with the Mpia, but also what would happen with those reports coming from the Mpia mechanism into, let's say, the real appellate review on a multilateral basis that we have with the appellate body. So I think it's a very hard question to answer at this point. But I would like to highlight that we all recognize that there's no precedent in the WTO, even though consistency among AB reports, etc., would present itself as giving this predictability to the multilateral trading system. So maybe I'll just leave Katherine with more of a legal topics.
No, I think I concur with everything that you've said. I think one thing to bear in mind, and I've seen quite a few questions on how old is the MPIA. This was announced, I think, last month at this point. So I think a lot of these questions are going to be a case of let's wait and see what happens. But I will, just a few points that I think let's call them guardrails, legal guardrails about how we can predict what will happen. The first is to remember that the MPIA will involve individual arbitration agreements brought by the parties by consensus under Article 25 of the DSU. So the reports will be binding on the parties. So we know that. The second thing we know is exactly what the ambassador says, which is that we don't have a rule of precedent in WTO law. So there's no instance in which a panel or, let's say, a future appellate body is bound to follow a particular interpretation of, say, a particular provision of the covered agreement. The other thing we know is that I think there's general consensus that security and predictability in the system is a good thing, and that consistent interpretations across the acquis of WTO law are positive. And so where you have a persuasive, well thought out, comprehensive arbitration report that is brought under the MPIA, I can't see any reason why panelists and adjudicate and future appellate body members would necessarily wish to depart from that. So I think ultimately, I suspect that this will be up to the way in which, on a case-by-case basis, the parties argue their cases, and it will be ultimately for individual panelists and appellate body members to decide how they will treat these decisions.
Thank you very much, Katherine. Joost, would you like to ask a specific question?
Well, by the way, those were not just trying to summarize what comes out of it. If we have some time left, I think if anyone attending now has a question which we haven't answered, perhaps you can put it in the Q&A box, because I think all the questions have now been shared with everyone. And make it as short as you can, because otherwise I see some questions that are half a page long, which is very difficult to get into. But Fernando, back to you if you had any.
Yeah, I was just curious concerning the manner in which the MPIA is structured. There is a reference to the fact that the arbitrators may speak among themselves, and I understand, correct me if I'm wrong, but this matter, the question of collegiality wanted to be addressed. Isn't that a departure from normal arbitration proceedings where arbitrators are supposed to, maintain reserve with respect to the matter that is discussed? To what extent this idea of having a discussion among the pool of arbitrators may be seen as something compulsory or something discretionary, depending on how they feel with respect to a specific situation? Maybe, I don't know, Katherine or Manuel or Santiago could give an answer to that.
I'm happy to just jump in really briefly and note that the text of the agreement says, I think it uses language like to the extent feasible or to the extent practical. So I think the agreement itself envisages, doesn't make this kind of literally compulsory, but I think it provides its own rationale as to why it's useful, which is that it contributes to security and predictability and consistency across the agreement. So I think the text of the agreement is, let's call it a strong encouragement to the extent possible, and outlines the reasons behind that.
Thank you.
So there is a question to Katherine that if some major countries join in, could the MPIA format become permanent? But I think it also refers to the idea that some aspects of the MPIA may lead to be part of the reform, which I think in your opening remarks you had mentioned.
Sure. So I'll touch on that briefly, because I think the ambassador has touched on this as well. If there's one thing that's really clear from reading the text of the agreement, it's that there is a clear desire on the part of the participating members for this to be an interim solution. So as far as we take that at face value, I think the MPIA will not end up being a replacement for the appellate body. It's an interim solution to make sure that disputes that are ongoing are able to, you know, reach their fruition. That said, I don't think that means that if something in the MPIA ends up working really well, like let's say the measures on time limits, let's say they're really effective, I don't see any reason why that can't be carried over into whatever a more long-term solution is. And it's kind of like a testing ground. We can see how these things will work in practice.
Fernando, I think we'll have to soon turn to Hugo for some concluding remarks, but I think it may be wise at this stage to, based also on the types of questions we've received, if everyone could perhaps make a final statement. And I would urge you to go back to the big picture, because I think we've delved into a lot of technical questions, but to go back to the question of, okay, if I'm representing a small developing country, what should I think of all of this? Or what move should I make? Should I join MPIA? Is this even worth my investment? Should I rather focus on PTAs, investment, whatever? So some concluding remarks, perhaps, on behalf of all of you, and perhaps we can start with Fernando.
Well, thank you very much, Joost. Indeed, I think it is very important that we try to find some sort of solution to this. Certainly, we cannot live in a world, in a WTO dispute settlement area where there is uncertainty. I guess this is something, as I mentioned at some point, that is maybe bearable now, but it's not sustainable in the long term. And I'm afraid that the situation is going to be more problematic in the near future, given the type of policies and the type of measures that countries may have to take in order to react to what we're living now. And I guess there may be some questions as to how, you know, this specific provision of, for example, Article 11 has to be interpreted, or how these requirements on transit have to be interpreted as well. And we have to have a dispute settlement body that could be suitable to face up the challenge. If we have a panel level that the decisions of which may be subject to appeal, and in the absence of the appellate body, then the question remains unresolved. That is not a good scenario, and that would rather further the idea that unilateralism is the only option available. So whether countries consider, you know, joining as an arrangement, something, I'm not saying, you know, the MPIA or something similar to that, or perhaps, you know, dealing with the right to appeal in a different manner, I think that becomes a critical question that they will have to face at some point, and I believe that's going to be sooner, relatively soon. So this is my remark. Now, I maybe give the floor to Santiago.
Thanks, Fernando. And just concluding remarks on my behalf. I would just say that and you probably noticed this through my remarks earlier in this webinar, but I'm a true believer of the multilateral trading system, and I do think that even though we do need to start negotiating a reform and how to modernize rules of the WTO so that we can face the new dynamics of international trade, technology, etc. I do think that the core values and principles of the organization, of the trading system, are still there, and we still need them. And one of those values, I think, and what was negotiated in the Uruguay round, is having a two-tiered system for dispute settlement mechanism. So I mean, and that's one of the reasons why Colombia also engaged in these negotiations of the MPIA. So of course, the idea is not to replace the appellate body, but if it is to try to safeguard those values, those principles of a two-tiered system in the WTO, while we can resolve on a multilateral basis the appellate body impasse. So I would say that I'm keen in seeing how this MPIA evolves, how the mechanism works, how it comes into practice, and eventually resolving all these questions that we had a hard time trying to answer in this video conference. But again, I would say that those core values and principles of the trading system should be safeguarded, and I think this is the way how we're trying to do so. Maybe it's not the perfect way, but it's the best available way at this time. So I'll leave it at there. Thank you, Fernando.
Thank you, Santiago. Now the floor is with Manuel. Manuel, please.
Okay. Thank you for this opportunity. Indeed, it's been a pleasure to see everyone and listen to read the questions. It is a webinar amidst this crisis. So just as a concluding point, I think we're at a very important inflection point of the WTO system. We have started the crisis with the swing of the anti-globalization, and the WTO AB reform and crisis is partially a result of this swing towards against globalization. And I share the view of Santiago that we must preserve the progress we have made and preserve the benefits of globalization while being sensitive to the new concerns that have been raised. With the COVID-19 crisis, we actually have a swing back to the need for unified global responses. And I think this is an opportunity for WTO to re-emphasize the importance of global unified responses. And so the AB crisis is part of this current context, that finding a solution is really answering the need of a unified global system, with respect, of course, for individual regions and countries. And I do see that the future holds some benefit for regional agreements, regional solutions, and a kind of more diverse dispute settlement system. There are disputes which will benefit from the two-tier traditional system. We already have seen some appeals resolved by no appeal agreements, which means a faster resolution at panel level. And we hope the MPIA will also lead to further alternatives. Thank you.
Thank you, Manuel. Katherine?
Yeah, I'll just say very briefly in summing up that I think one clear position that has emerged from the discussions today is that there is a real commitment to a binding system of multilateral rules. And as well as that, a functioning and effective dispute settlement system whereby members can make the most of the rules and the obligations that are owed to them. And I think we've heard that that's the case, not just for members that are really regularly using the system, but the existence of that structure is really helpful for the membership as a whole. Now, of course, there can be and there is a lot of disagreement about the precise mechanisms by which we undertake dispute settlement practically. But I think there are two things that are clearly important. One is the existence of appellate review, and the other is the binding nature of panel reports. And I think there's a clear commitment from a large portion of the WTO membership, and I would say most of the WTO membership, for those things.
Thank you very much, Katherine. I think with that, we conclude our interventions, and now we're giving the floor to Panizza, who's going to make the closing statements. Thanks a lot.
So thank you very much. So to Joost and all panelists, this was a great debate. I'm not an expert. I'm an economist who doesn't do trade, and so I don't know about trade and I don't know about law, but I learn a lot about this. This is the first time that we cooperate with the Joost Center to do this type of event as a journal, as international development policy. We will have another one next week, more focus on the economics with Richard Baldwin, who directs the center together with Joost. So again, I'm not an expert of this field, but let me maybe in 1 minute say what are my takeaways from this discussion. And I came out from this discussion, you know, a bit more optimistic the way I entered. One thing that I learned is that, you know, maybe the situation is not so desperate as I thought before this panel, from my completely ignorant position of the WTO process. So as panel becoming more important, and I like sort of the silver lining of was mentioned by Katherine at the beginning, that is say, you know, reforms are also always difficult, and my big crisis are a good thing for reform, and so maybe this would be a way to move from the old status quo to a better status quo. Let's hope, finger crossed. Ambassador Tehankee sort of stole what I wanted to say at the very end, but I think it's great. So great mind thinks alike. And, you know, it was exactly my feeling that, you know, we were in a situation in which multilateralism was sort of a bad thing. So we had many leaders taking strong position against multilateralism, especially leaders of a very large and important country. The COVID-19 crisis might be a silver lining of the COVID-19 crisis, is that it's showing that we're all in the same boat, and interdependency, you know, whether we want it or we don't want it, is there, and we have to cooperate. So maybe again a silver lining of this crisis that will come out from it with more support for multilateralism, and this will be good for many things, and also for the WTO. So I'll close here, and again I want to thank all the panelists, and I think this was a great panel. We wanted to do it live, but I think it worked very well online as well, and it allowed people who are not in Geneva to participate. Thank you very much.